Good evening, chat. Hello. It is Saturday night. It is, it's still raining. Jeez, sucks out there. It is like 7 o'clock, and we've got kind of an update and a little bit of I wouldn't say it's the side show, but it's an interesting vein of the Karen Reed saga, and it's what's going on with Turtleboy, Ian and Carney. Now, I understand, before I've said, I thought he was a bit of an idiot in how he did his things. I still think his actions are protected, but do I think he could have done them differently? I still think that, but at the end of the day, given how the Commonwealth has treated him, I really don't fault him at this point. Given how he's done all this, I kind of assume he kind of, I'll defer to the Canton in, suburban Boston subject matter expert, that he is, and how to deal with these people. And if this is how it had to be done, I assume it's how it had to be done. So we're going to take a look at his ongoing issues with the Commonwealth of Massachusetts and their attempts to jail him because he says things they don't like. And he brings up things they don't like. And we're going to get to that. And if you guys are new, my name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area, and we're going to be looking at his hearing he had this past week, which immediately turned into a bond revocation hearing. They attempted to put him in jail. It failed. That's good news. But we're going to go over that. We're going to talk about it. We're going to see what happens there. So that is the game plan here. And there is a channel who did record it. The Young Jerks, they're part of the kind of like the Glare and all those other people. They're kind of part of the Karen Reed ecosystem. I did speak to their guy in charge, Mike. He said he was cool if I used it. So we're going to use their recording of the hearing because I don't have it otherwise. I don't think it's out there otherwise. So Ben said, sorry, where's Clyde? Who's this guy talking? Well, hold on here. Clyde, come here. Come here. Come on. Hey. Clyde, up here. Come here, Dingleberry. There you go. You have to ignore him when he comes close. And then... Jesus. What has gotten into you, Bubber Bear? Anyways, there you go, Clyde. There you go, chat. He's like... You got your Clyde for now. Yes, Mike is the guy who runs the Young Jerks. He is great. I've watched his stuff a couple of times. I very much enjoy it. So, yes, Bork. What is it, Clyde, huh? What's that? Jen McCabe committed perjury? I know, buddy. I know. We all know. It's okay. We know. It's okay. You can tell them. Tell them. You think Karen Reed's committing, or you think Jen McCabe's committing perjury to Karen Reed? Tell them. Jen McCabe's committing perjury. Woof. You heard it. Jen McCabe committed perjury. He said so. All right, guys. So we are going to get started here. And I think the first thing we should do is take a look at actually what they filed, because we're gonna skip through parts of it, but I think it's important we take a look at it because it does matter to what we're doing. Why did this not work? No, there we go. That's why my messages. I hate this when you're on Twitter and the message is like, something happened. We can't use your stuff. Retry. It's like, I don't know what better of a connection you guys need to check things out or use things. Okay. So the way this worked is the Commonwealth did file a motion to revoke. Tell your bestie Elon to fix it. He's not my bestie. He's daddy, Elon. No, Jen was not charged with perjury, but she should be. She should be charged with being a bitch too, but obviously that's not a crime in Massachusetts. But this is the document here, guys. This was what they're filing. They're seeking a motion to revoke his release. Now, ultimately, Turtleboy is facing all the charges of witness intimidation and witness tampering because he dares confront and accuse all these scumbag witnesses in the Karen Reed trial for being lying pieces of shit. And that's all he did. That's all he did. And what happened? Well, the prosecutor mentions on March 6th, there were imposed conditions of release. He was given bail warnings that were read by the clerk. Those conditions of release included an order he was not to contact either directly or indirectly any witness in his pending case. Now, they talk about Lieutenant Tully. Lieutenant Tully is the lead detective, kind of was supervising everything in the Karen Reed case. He is a witness in the Karen cases. He's also in, Turtleboy's case too. He's an affidavit for the search warrants executed at Turtleboy's home. He testified pursuant to the indictments. And is this showing up for you guys? Good, it is. Yes, it is bullshit. Yes, if being a bitch was illegal in Mass, Karen would have been charged with it too. Yes, I very much don't I don't disagree. All the women in this saga, and ladies, you'll have to forgive me. It sounds like all the women in this town, all the women involved in the story are a bunch of bitches. They all sound like bitches. But I think you guys, women know that because game recognizes game. That's so it's okay. You guys know that, and you women know this. So, on April 26th, Turtleboy did a live YouTube video which he declaimed as follows: Tully is the mastermind of all this shit. Fuck that corrupt piece of shit. So far, okay, whatever. It pisses me off that he gets away with this shit. Fuck him. He was rehomed. But he's still involved in my case and tried to have me locked up again last month. He can say that. So far, no crime committed, no bond violation. He could go get fucked. Him and his stupid wife and his stupid family. Still, I hope they all fucking die in a fire. Okay, still, I don't see the problem. Fuck them. If I found out tomorrow Tully was burned alive in the most painful way possible, I would be so happy. Now, I will say the only thing that gets you a little iffy here is, God forbid he had like a house fire. Guess who's coming knocking on your door? So you have to be careful. When you wish somebody death, don't wish it a very specific way if it's possible that it could happen. Because then, then something might happen and then they might come talk to you about it. So you have to be very careful. He says, I would be awesome. I'd be great. I hope he dies. Still fine. I hope pain and misery happens to him after he's done to me, what he's done to Karen Reed, what he's done to my children. I like how they misspelled Karen's name there. I really fucking hope, I would get so fucking hard if he told me Brian Tully died in a car accident tomorrow. Brian Tully actually deserves to get hit by a car and die. 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 And so I don't give a fuck if he dies. I don't give a fuck who he leaves behind. I hope it's painful. I hope every single waking moment of the rest of his life is miserable, because that's what Jesus would want me to do. Okay? I go to church every Sunday, and that's what Jesus talks to me, and that's what he says. Revenge. Okay, so what? There's nothing illegal here. There is nothing illegal here. Minority Reporter says, damn, this dude was pissed. If you got jammed up on 19 felony charges and you were going to possibly go away for the rest of your life, you would too. You fucking would too. Aaron says, Sean, you did that about Gen M the other night. Yeah. So this is all speech here. I have no problem with it so far, but let's see what else we got here. All right. So they say the statement is quoted above mandates revocation as bail on at least two alternative grounds. Oh, no, you mean one ground and then you're the ones on argument and alternative. That is a poorly worded statement. First, it violates the order of no contact, direct during contact. How? How is this indirect contact? Kearney is aware that Turtleboy is aware that Tully is the chief investigator. Even if he doesn't know, even if he does not view the show in question himself, it is highly likely to be informed of Turtleboy's remarks by a citizen viewer. One of the named victims in the defendant's indictments against Turtleboy, who's been the subject of Turtleboy's harassment, and who monitors his broadcasts, or simply a concerned citizen who happens upon it. Okay. So what? So what? He gets informed of it. So what? That's not an indirect. That's not indirectly. That's still not. No. And they cite a case though where somebody was making they weren't attempting to contact the victim. They violated the no contact probation order by making statements in the newspaper. Well, he wasn't directly saying it to him. He was just saying, "I hope shit happens to him." This is absolute bullshit from the prosecution here. And they say, although Turtleboy's comments were reprehensible, are they really reprehensible? I don't know. Scumbag cops get what's deserving. They get what's coming to them. I don't feel bad for them. I don't feel bad for scumbag cops getting what they deserve. Shit happens. Their content is essentially irrelevant for purposes of determining whether or not there was a violation of the order. Okay, so their content is irrelevant. All right. It is the fact of any communication, not the particular content thereof, that determines a violation. Yes, but without the content, how do you know what the fuck is happening? I don't know. Second, the revocation of Carney's bail is mandated because there's probable cause that the act of broadcasting his comments constituted a crime, i.e., intimidation of witness. There is no doubt. Everything's a fucking intimidating a witness. I'll probably get intimidating a witness for this at some point. That Cully confidently falls within the people who are involved. Yes, he is an investigator, a witness, or a potential witness. He is most certainly a police officer. And the comments are not directed at Tully, but his stupid wife and stupid family. His stupid family, chat. Oh no. Hold on here. It's his stupid wife and family, chat. It's like, oh no. His little retarded kids. Tully's stupid little children and his retarded wife. Oh no, chat. No, it's such a travesty. Oh, the humanity. Oh, the humanity. Oh, the humanity. Whom Turtleboy wishes would all fucking die in a fire. Okay, so maybe they all should. Should they all die in a fire? I don't know. They too are explicitly protected under the statute. Finally, for purposes of the witness intimidation, Tully's a witness not only in the cases, but in the Karen Reed case presently on trial. As a member of protected class, the statute criminalizes either direct or indirect threats. The comments are threatening on their face. How is it a threat that I hope you get cancer? I hope you die. You know, I hope your 401k bottoms out. Like, no, those aren't threats. Those are not threats. They're not threats. You know, they point out here, they cite a case that language is a threat in absence of an explicit statement of an intention to harm, so long as they support the victim's fear. Yeah, but you've got a big problem. You've got Counterman versus Colorado that's out there, where it has to be, it has to also satisfy the defendant's subjective thoughts it was intended to be a threat. You've got some issues there. But this is absolute bullshit. They're not threats. I hope you stub your toe. That's not going to work either. How would that work? They talk about the earlier motion to dismiss filed argued before Judge Doolin and still under advisement. The defendant argued that the law was unconstitutional on its face as applied and runs afoul of the First Amendment. They talk about the Commonwealth and what they argued here. Maintained the statute was constitutional and that it sets forth reasonably carefully limited restrictions to time, place, and manner, which once again, chat, those are the limits to what you can do. A time, place, and manner restriction. Those are always seen as reasonable. Those are the accepted ways to do it. The Commonwealth maintains its position and assumes the defendant does as well. This court need not launch into an examination on whether the comments fell outside the First Amendment's protection as fighting words or true threats. I don't know. You know what I'd say? Fuck it. Prove these are threats. Prove these are fighting words. You know, true threats include direct threats of imminent physical harm. Okay, well, those aren't. He's not threatening it. You know, anything that would cause a victim a fearful or apprehensive response. The guy hopes your house burns down. He hopes you die. How do you fearfully react to this? I don't know. The examination is unnecessary because the Commonwealth does not rely solely on the spoken word. As with the conditions set forth, the defendant's delivery of his comments on an internet presentation seen by thousands is conduct apart from the words expressed and an obvious attempt to intimidate. Wait. They said that doesn't matter though. They said that doesn't matter earlier. They said it doesn't matter. They said it does not matter. And I'm trying to see which page. Where do they have they mentioned that? Yeah, here we go. This is the interesting part here where they say none of that matters, but they talk about the content is essentially irrelevant to determine whether there's a violation of the order. The content and manner of it apparently does matter because now look at them later. We're on page 5 and they're crying about this. They are crying about this because we come back and they're not relying solely on the spoken word, but they're still crying about it. So, hey, Turtleboy, how you doing? Yes, he's a grown man. He's got a bulletproof vest and a shiny black gun. I mean, that's what you get. You're a cop. Lieutenant Tully, strap up, buddy. Like if you're worried that this is going to happen, go ahead and do it. Although all you said was your house is going to burn. Like you hope his house burns down. Guess what, Lieutenant Tully? Buy a fire extinguisher if that's what you're scared of. But yes, this is absolutely pathetic bullshit. But oh no, we're not relying on the spoken word. But what he says doesn't matter. Guys, I would bring him on, but I would be very concerned. I don't want him to say anything where they give him any more ammunition. But that's kind of where I am with that, because this is like if he farts at this point, they're gonna try to fucking revoke his bond. That's what they're gonna do now. I guarantee it. So, Aiden, don't fart on camera because they'll probably try to come after you for that. Yeah. Yes, having an audience of thousands. Well, that was something we brought up earlier. Like, so what if there were no people around and nobody watched it? Would that make it okay? If you were just screaming into the void for like 2 viewers, or like me to like, a handful of people, does that make it any better? No. So, yes, unless he's streaming from Tully's front yard, he's probably safe. Oh, yeah. Yeah. So they say, certainly and alternatively, the comments may be seen as an attempt to cause emotional injury who they made to his family, who may justifiably fear that one or more of the defendant's fervent followers, doubtly fortified by the alleged approval of Jesus himself, may decide to assist fate in bringing about the death by fire or auto accident, Lieutenant Tully, and his family. Okay, this isn't Hillary Clinton. Turtleboy is not able to orchestrate that. Yes, if this was Hillary Clinton out there talking like this, yes, and I was Lieutenant Tully, I'd be terrified that I'm going to die and my family's going to die. But this is not Hillary Clinton out there. This is just Turtleboy. More of the criminal statute criminalizes retaliatory actions against any person in the protected class. The defendant's hopes for a fiery and painful death, notice hopes, not demands, not guarantees, a hope, are in his own words, as he attributes to Jesus de Cristo, revenge. Okay, I hope Lieutenant Tully stubs his toe tomorrow. Is that a threat? Is that a threat? I hope Lieutenant Tully gets kicked in the balls tomorrow. Is that a threat? I hope Lieutenant Tully gets constipated. He's got to go to the hot ER and they got to flush him out. Is that a threat? Is that a threat too? I guess. State of Massachusetts, let's go. Let's go. Slap the cuffs on me. Let's do this. As the defendant explains, I hope he dies. Like, I hope pain and misery happens to him after what he's done to me. Okay. Yes, I too wish poor things to happen to pieces of shit who abuse governmental authority. I too wish upon them horrible things. What he's done to Karen Reed and what he's done to my children, yes. You know, it's interesting. The Commonwealth forgets, like, there's other people being affected here, too. And what, by the way, is Lieutenant Tully done to Karen Reed? You mean other than running a corrupt investigation that she's now looking at and locked in a box for the rest of her fucking life? You mean what has he done? What hasn't he done? What hasn't he done to this woman? Investigated the death of John O'Keefe. Okay. You know, supervised other officers involved in the investigation, and how many of those guys are no longer officers anymore? How many of those guys are fired? Yeah, how many of those guys? He testified at the grand jury. Okay. Which found probable cause to indict. That doesn't mean shit to me. A conclusion affirmed by this court in denying a motion to dismiss and denying a motion for directed verdict in the first trial. In other words, he did his job as a police officer. Really? Really? I'm pretty sure he got reprimanded for part of his supervising of that. I'm pretty sure he got reprimanded for supervising Buchanan and Proctor. Turtleboy, you can correct me on that. I'm pretty sure that's what happened. So he didn't do his job. Also, by the way, what has Lieutenant Tully done to Turtleboy and his children? Well, I mean, he's threatened to take Turtleboy away from his children and lock Turtleboy in a fucking box for the rest of his fucking life. I think that's a pretty big deal. You know, like, that's a big deal. You put him in jail for a couple of days away from his children. That's a pretty big deal. You executed search warrants on his home where men with guns showed up. That's a pretty big deal. I mean, even though Nick Revocation said that's no small thing for kids to see guys coming in strapped up and entering your house forcibly. You know, he investigated alleged intimidation of witnesses. He served as an affiant for search warrants. You know, warrants duly issued by the courts. The warrants were issued by the courts doesn't mean anything. The court's relying on the officer not to lie. That's a horrible argument. That's an appeal. That is a horrible appeal there. Well, the court said it's okay. Well, that doesn't mean it's legitimate. Executed those warrants. Arrested Carney. Well, maybe that's a problem. Advised the Medfield police of alleged criminal behavior by Carney. Reported him by telephone by another witness. And most recently, upon receipt of information from another witness, sought and received a criminal complaint in the Stoughton District Court. I know I butchered that. Against which Turtleboy's motion to dismiss proved unavailing. Again, simply put, Tully did his job. Oh, yeah, that's right. That's right, chat. True American hero, Lieutenant Tully. You know, that's it right there. And it's that for which Carney acts to retaliate and accomplish his explicit and publicly stated purpose of tainting the jury pool. Well, you know what? Even if that was his goal, I don't care. The state's not entitled to a fair trial. Only Karen is. So they say because this is a felony, upon finding there's probable cause, the rebuttable presumption arises that no condition or a combination of conditions will assure he won't pose a danger to the safety or another person in the community. Okay, well, who's he going to hurt? They say there is no reason to suppose that additional modified conditions will deter Carney any more than past orders of this court. A court which he manifestly regards as an impotent prop. I mean, okay, and I'm just saying, like, okay, like, yes, this is all a fucking charade. Yes, this is all a joke. Like, I'm not. I mean, am I wrong so far? I agree with you. Yes, he signed off on all Michael Proctor's reports. Yes. Oh, he was in jail for like 90 days. I'm sorry. Yes, it was 90. It was like 90 days. I'm sorry. That's a long time. But yes, it's no big deal. It's just no big deal. It's no big deal. So, for the reasons set forth below, and as such others in the court may find on hearing, the motion should be allowed. I mean, you can, just imagine this. Imagine being Lieutenant Tully, and you are a police officer. You handle very serious violent crimes. You handle murder cases, and all this happens. And what does Lieutenant Tully do? His just starts flopping and slopping out his puss. I mean, the sand must blow around out in Norfolk County. The sand just blows up into his folds, and he gets sand up in his puss like none other. That's all I can say there. That's all I can say. I will fund Lieutenant Tully if he needs like a douche. Like, how much money does he need? I'll crowdfund one. Chat, we could do that. I know you guys would help me. Getting him a douche to flush the sand. That's all he needs right now. That's all he needs. Yeah. And Karam's right. Without Turtleboy, guys, nobody would have cared about this case. He brought this to, everyone. That's why we're all watching it. That's why everybody knows about it. So yes, I get it. They're very upset about this. Kate B says Turtleboy cried in jail every night. Let's say he did. I know you want to troll here. Let's say he did. So what? You ever spend a day in jail? You ever spend a night in jail? You ever spend a month in jail? 2 months in jail? I guarantee you sit in jail, you're going to be bawling your fucking eyes out. Realizing your kids are like, mommy or daddy, I miss you. Like, being incarcerated ain't no fucking joke. Ain't no fucking joke. So I know that didn't work the way you thought it was going to, but there you go. So. Let's move on to and guys, the Young Jerks, they are part of, like I said, they're part of the ecosphere. Spoken to Mike. He is allowing us to gracefully use his stream to cover the hearing, and we're gonna get through this. We're not gonna go thankfully we're not in slow trial mode where it's like 1 point whatever, and we're gonna die if we go a little faster. But we're just gonna slightly speed up a hair, just so we aren't sitting here all night. But we are going to start with this and go forward. We got closed captioning on. And I don't blame Mike. He's, super chat stuff pop up on the screen, but that's from his channel. And you know what? That is, we're going to have to deal with that. So if you guys can't deal with that, or it gets you all stimmy, you can't read everything at once, I don't know what to tell you. We'll figure something out, though. So let's go.
All right. What's the first order of business, Mr. Cosgrove? I'll start with you. I see counsel from New York is on as well.
Yes, Mark.
Hi, Mr. Beddoe. Good afternoon.
Nice to see you.
Good. Okay. What's the first order of business, Mr. Cosgrove?
Your Honor, I think the first order of business, I would at least like to take up the issue that has been hanging for quite a while regarding the search of the seized devices and the memorandum that I filed response to your Honor's order last time in opposition to what I understand to be the defendant's motion to...
Yes, chat. Turtleboy has his own, he has local counsel, but he also has Mark Bedrow. You guys have seen him all over the different shows. He was actually trying to get on Karen Reed's team prior to the beginning of the second trial, but it was not allowed. Judge Canoni didn't allow it because she's a fucking retard. But anyways, that's him. He's one of the other attorneys involved for Turtleboy.
Screen other things besides attorney-client privilege, specifically reporter privilege.
Okay.
And I'm as I was leaving for court this morning, I received a text from Mr. Kearney indicating
Bob. How are you
that
doing?
he intended to rely for his filing on something previously filed. I unfortunately do not have that with me and have not been able to look at it. But as far as the argument itself goes, I'm more than willing to rest on my filing for the most part, particularly if Mr. Kearney is as well. I'm sure I reviewed that other document at some point, although it's not fresh in my mind now.
Okay, so what you're referring to is that there is a taint team that's in place.
There is a taint team in place.
That's Judge Macy, right?
Judge Macy is the,
Now, chat, before we get too far, because when they seized all his devices, there was a protective order put in place, and it's requiring a taint team. A taint team is an independent team of people who go through the documents, in this case, which Turtleboy's phone and his devices. But let's say that he's a reporter 30 years ago. He's going to, have all his files, all this stuff. Somebody independently needs to go through that because he's a journalist and there's privileged material. Or on the other hand, let's say Turtleboy was an attorney and they seized all of his documents. Well, there's attorney-client privilege material there. So an independent party is going to have to go through that to make sure what's privileged, what's relevant, and what's not. Because we can't just let the cops go through all of it, because then they learn all the secrets. They learn everything, because Turtleboy might be working on 100 other stories right now. So that's what the taint team does. They're meant to keep the taint of, and not that kind of taint, chat, of inadvertent disclosures of things and breaching privilege from happening.
evaluator, so to speak, of privileged material, what should be turned over and what should not. And Mr.
Okay, Turtleboy saying, we found out they already went through my phone without the taint team, and 2, the 4 phones in question are like 10 years old, found in the back of my closet. Oh. Well, so that should be easy enough for them to say there ain't nothing there. But I'm sure that they're going to not surprised they went through it without you. Without a taint team in place. It's not a surprise. Thank you for providing that info, though.
Verino is the electronics expert that would actually do the search. And my problem, Your Honor, is that they fulfilled their part as far as they could by returning within, I think, a week of Judge Krupp issuing the order, their acceptance of the order and the responsibility to undertake that. And as far as I know, the court has not forwarded to them the appropriate search terms. I don't know what search terms Mr. Bradle supplied or what they...
Let me just ask Mr. Bradle. Mr. Bradle, did you supply search terms?
I did, Your Honor. Document 67, I believe.
Number 67. Okay. Have you seen that, Mr. Cosgrove, or is that something that's outside your view?
Well, Mr. Bradle had permission to file them ex parte, so to speak, if he believed that they might disclose something inappropriate to the Commonwealth.
So you want me to forward that to Judge Macy and to Mr. Verino?
Well, I don't know that I do, Your Honor, because I want you to make an evaluation first of the appropriateness of those terms, which the court is supposed to do under Judge Krupp's order.
Okay. I'll take that. I'll do that myself.
All right. I appreciate that. And I would say if the court wishes to hear further arguments at this point, I would say just forward it all to Mr. Verino, tell him there may be further instructions coming from the court.
Okay.
Because it's been, 4 months now?
Okay. I'll do that. I'll forward it. Okay, I'll take a look at what Mr. Bradle has requested. If it's appropriate, I'll do as you request, okay?
All right, thank you.
Mr. Bradle, anything you want to say on that?
Yes, thank you very much. So, Judge, in document 67, it was just the original filing on this very issue where I asked for this hearing. And so in that case, Judge, there's a 1985 case, which I would kind of call it, had a long, convoluted name. I would just call it the Petition for Protection of Confidential News Sources from 1985.
Yep.
And it's still good law. And it addresses the situation that there's no statutory journalist privilege in Massachusetts. And it says that courts should deal with it on a case-by-case basis, as we are here, of course, and address issues as they come up. And just a quick quote from the case, Judge, is that this court should consider alternative remedies for compelled disclosure of journalist source material.
Looking forward to
And
it.
my client has informed me, and he has previously sworn in an affidavit in this case, that his phones contain journalist source material. This wide swath of electronics that the government has seized in this case, that there are areas where there are journalist sources. And
It's about witness intimidation, but it's about silencing people who are kind of blowing the lid open on things here. So yes, the witness intimidation is the vehicle for them to go after Turtleboy.
alarming, most eyebrow raising, Your Honor, is that there are some instances where there are sources giving information on these very same state police actors in this case that we have been criticizing and pointing out errors and alleged corruption on. These people are the ones that are going to get this information.
Mm-hmm.
Not even like the FBI or a third party. This is source material on the people that Mr. Carney has been criticizing in the Karen Reed case. So I can't think of a more important case where a court ought to craft an alternative remedy for compelled disclosure than this. We have these conflicted officers who have, we contend, perverted the witness intimidation statute for their own goals, and now they possess my client's electronics, and they're going to go through them for source material on their own wrongdoing, their own misdeeds. It's unbelievable. It's like a John Grisham novel, Your Honor. So this court is in a position to say,
Okay, real quick. There's no such thing as a certified journalist. If you are commenting and reporting on a story of newsworthy value, you are a journalist. Right now, I am doing journalism. I am commenting on a story of newsworthy value. So that's what it matters. Yeah, like I am a journalist. So yeah, there's no specific like getting licensed as a journalist. And certainly what he's doing is journalism. And yes, Bradel's making a great argument too. We're getting information from sources that are out there. People are telling me and reporting in about how big a piece of shit these cops are. Well, now the cops are get to read through that and find out who's telling on them. And that's a very dangerous issue. So.
time out. Under the petition for protection of confidential sources, I can craft a remedy here. In fact, I think it's the court's duty under the First Amendment in Article 16 to craft a remedy and say, time out. The Taint team is going to be sworn in under oath. They're going to provide information relative to the search warrant, relative to the court orders.
Very true.
But they may not provide any journalist source material, in this case, to the Commonwealth. And if there is an issue with any such material, it will be isolated off to the side. The court can look at it in camera, along with the defense, sort of like a Lumen Martin type situation, Your Honor, and we can take it from there. That would be my request on that. And I think under that case, that would be the appropriate remedy for the court to address here.
Okay.
Thank you. That's all. Thank you.
I get it. All right.
Can I?
Yeah, no, go ahead. Go ahead.
First of all, I heard Mr. Bradel say that Mr. Kearney has produced an affidavit claiming that journalist sources are contained within these electronic devices. I don't claim to never miss something, Your Honor, but I don't think I've seen it. So I would ask for some specification of where
Yeah,
that.
Mr. Bradel, is that part of in-camera Exhibit A?
Judge, I can't tell you off the top of my head. I want to say it's probably 30 or 40 documents ago, but I'm happy to get it to everyone when I can get to my.
None of us would have known about
Okay,
this.
that's fine.
We're
Why
caring
don't you
about
do that? Why don't you send a copy to Mr. Cosgrove and send a copy to Attorney Sano?
The second thing I would say, Your Honor, is that, and I'm not necessarily opposed on principle to making new law, but I think I'm correct in saying that if the court rules that the Taint team screens for anything other than attorney-client privilege, it would be the first case I am aware of in the United States that has ever had that holding. And I think it would also be the first case where the so-called qualified journalist privilege has not yielded to the demands of and the interests of the government in terms of vindicating search warrants and.
You know what? Too bad. Suffer, Mr. Prosecutor. Suffer. I don't mind that. If that has to be, so be it. So be it. Let it happen. Let the heavens fall. Let's see what happens.
And criminal law. And finally, if I could, Your Honor,
No, go right ahead.
Judge Krepp's order also set a time, I believe, for Mr. Kearney to provide the Commonwealth with the passwords to these electronic devices. And I don't know whether there's been a formal answer on the record to that.
Let me ask Mr. Bradle. Do you have a response to that? About Judge Krepp's order?
About passwords, Your Honor? I'm sorry.
Do you know what paper that was, Mr. Cosgrove?
I'm afraid I don't off the top of my head, Your Honor.
All right. So what you're saying is that there's an order from Judge Krepp that orders Mr. Kearney to provide the password to the device?
Yes, it's set out in the procedure of Judge Krepp's order.
All right.
And I don't know if well, let's put it this way: if Mr. Kearney has already provided that to the court, we need it, or rather, Mr. Verino needs it in order to feasibly open the devices. If Mr. Kearney is contending that he's forgotten the passwords, we need to know that so that Mr. Verino can proceed under what measures he can to crack the devices without the password. Or if Mr. Kearney is maintaining that he has a Fifth Amendment privilege against disclosing the password, then I think still I would tell Mr. Verino, or ask the court to tell Mr. Verino, that he may proceed while proceedings are underway here. But I would then file a motion to have the court adjudicate whether he in fact has such a Fifth Amendment privilege.
Okay. Mr. Bradle?
Yes, thank you, Your Honor. So
You do have Fifth Amendment right not to compel to, when you're at the border too. That's why you don't have like Apple Face ID, a fingerprint or a Face ID. Those aren't protected. They can shove the phone in your face and open up your phone. But if you have a passcode, you can withhold that. So there's an advantage. Don't use Face ID, Chat. Don't use fingerprint ID.
at this time, we're not pressing any Fifth Amendment issue. My remembrance of the case law on that is not, it's not particularly solicitous.
No, I agree. Yeah, I think that there's a case on point from the SJC.
Right. But Your Honor, some of those devices are pretty old, and some of them are old and not Mr. Carney's. So there's some issues there. What I would suggest on that is that if there is, I happen to know that the state police do have at least one, if not two, of the passwords of the devices that I think they're primarily interested in. And my thought is that they can report back if they have any issues, and we can take it from there.
Okay.
Is that all right?
That's not the order. The order is that he's to turn over the passwords.
Right. Mr. Bradle, have you responded to that in any way? Have the passwords been turned over? Is there?
Judge, I think that
I mean, if I don't, obviously, as you both know, I've come into this afternoon after one of my colleagues has been recused. So I'm trying to just kind of narrow the issue here a little bit.
Sure, Judge, we're not opposed to doing that. My thought was that we were resolving this stuff, and then once the court was given the green light to the Taint team, we'd be happy to do whatever the order say.
All right. Okay, I get it.
I just was sort of chronologically looking at it. This was the next thing, and then we'll be happy to comply with whatever the order is.
Well, you already got an order from Judge Krepp, so what I would suggest is I'll give you 10 days to comply with that, okay?
Okay, thank you.
All right. Next thing, Mr.
And I am agnostic, Your Honor, as to whether I will yield to Mr. Bradle's preference as to whether he wants to go forward on my bail revocation motion or whether he wishes to press his discovery motion at this time.
Okay. Judge, I'd like to be heard on the motion to compel, if I may.
Okay. The motion to compel. Go right ahead, Mr. Brattle.
Thank you, Judge. I'm not going to belabor it. I'm not going to just repeat the written filing, Judge. But, it's been a long time. There's been many discovery orders in the case. One comes to mind, May 8th, from Judge Cahalane of last year. And still here we are. And there's also, if I may, Judge, there's some qualitative issues that we have as well. We've gotten screenshots of text messages, very important text messages. And that is just not an adequate measure of compliance with providing text messages, Your Honor, because we don't have the whole string, we don't have the metadata. And something that just occurred in the Karen Reed case the other day, excuse me, was that a witness named Terry Roberts took screenshots of her text messages that were provided to the defense as screenshots, here, same exact situation as we are here, and did not, in my opinion, give good faith answers to foundational questions about whether they were her text messages. And these text messages.
And that's a thing, chat, because it's like you're taking a picture of something else. I can't authenticate it. There's no way to authenticate the metadata or anything with it. Where if I have the actual text messages and the actual electronic data, I can verify things. If I'm just given a picture, like if I do something boomery and take a picture of the screen right now, you can't analyze any of the data I'm looking at on my screen, any of the programming, what the state of anything was. Because if you just have a picture, it doesn't tell you anything.
Were not admitted. So here we are. And that's a perfect example of why screenshots of text messages, sorry, are not something that ought to be
and that's why having the authentication would be there.
So we need the digital copies of these items. They're ordered, they're supposed to be given, and these sort of piecemeal pieces of paper with no foundational support, no assurance that it's the entire string, and they're really not the entire string.
Well, I know why they're doing
these
it.
These really need to be given to the
defense
defense as a matter of due process, Your Honor. And I can say the cases, but you know them.
Okay, let me hear from Mr. Cosgrove on that.
Before I get to that, Your Honor,
go ahead.
I would like to address a few things. Specifically, I would like to start with the affidavit that has been submitted in support of the motion.
Okay.
Has Your Honor had an opportunity to review that?
Which paper is it? There you go. Let me see. Yeah.
Well, let me see if I have an extra copy.
Okay. I'm familiar with that.
Thank you. All right. I know Your Honor looked at it and entered a preliminary order.
Yeah.
Allowing the motion for impoundment pending today's proceedings. And I want to place the court on notice that I object largely to the order of impoundment. I don't object the impoundment of the name of the witness in item number 8, who is allegedly described.
Impoundment, chat, means they're going to keep it sealed and keep it out, like nobody's going to get to know it.
With an obscenity, although that is the least of the characterizations of his behavior, allegedly described that way by Ms. Peter. But I do object to the affidavit being supported by what in effect, for the record, would be an anonymous affiant.
And chat, this is that affidavit we went over last weekend. The affidavit talking about Kate Peter and her involvement in all of this, getting compensated, receiving compensation from Jen McCabe, and the interconnectivity between the anti-Karen Reed ecosystem and the Norfolk County DA's office.
I particularly object to that because before the ink was dry, Mr. Kearney essentially outed the name of the affiant on his own YouTube presentation, and her identity was discerned by Ms. Peter the same day and was the subject of an extensive post on YouTube. So there is no purpose at this point, Your Honor, to allowing her to pretend to hide behind an impoundment order.
Okay, I got it.
All right. Moving on to that, Your Honor.
That's the funny thing. Kate Peter outed the name already. You can find her name. Her name's all over the place. Kate did a whole freaking schizo rant about her and everything about her. I'm not going to put her shit out there because that's not fair to her. But she is out there. If you look for her, you can find it. It's not hard at all.
I object to the affidavit. I think that Mr. Kearney should produce the affiant, or that the affidavit should be stricken. This affidavit largely recounts purported hearsay by Ms. Peter, and I'm not going to go through them all one by one, but I will say
all affidavits have hearsay. That's pretty much all affidavits do is have there's some information in them, but a lot of times affidavits contain hearsay. And if we're worried about affidavits containing hearsay, wow, I guess we shouldn't do search warrants because most of the information in search warrants going to be fucking hearsay. Isn't that funny how that works?
Say, for example, that the assertions set forward in the affidavit are so preposterous and outlandish on their face that I really, I don't mean to be overly critical of brother counsel, but I really question the judgment of counsel for Mr. Kearney in going forward and filing it. For example, if Your Honor will look at item 6, supposedly Ms. Peter said, and the affiant repeats it as gospel, that at one point in the jury deliberations.
Well, do you want the affiant to be making things up? He's repeating it as gospel. Do you want him paraphrasing or lying? Do you want him acting like Kerry Roberts, lying to the grand jury? Do you want her acting like Jen McCabe, saying, I didn't say that? Do you want her acting like, firefighter Nuttall, saying like, oh, I heard all this, and it turns out, well, I really didn't? Not realizing what the victim was wearing at the time. Yes, he's repeating what he heard word for word. I know it's a unique concept for the prosecution to not understand why that's important, but it very much is important.
Ms. Peter met with a prosecutor for lunch, and that during the lunch meeting, doesn't say where, doesn't say when. During the lunch meeting, the prosecutor was indiscreet enough to tell Ms. Peter that he knows the foreperson, who is a retired police officer, and he, the juror, is guaranteeing a mistrial. Now, does that make sense to you, Your Honor, that an experienced prosecutor, and I don't know if the name prosecutor has appeared in front of you?
I mean, does all this make sense? No. But if when I heard the initial story to Karen Reed, I thought there's no fucking way this is true. When I heard the whole story about Sandra Birchmore, I'm like, no, there's no goddamn way that could happen. That makes no sense. Guess what? Yes, it did happen. Sandra Birchmore happened. That defies reality. If you wrote that as a story, it wouldn't be believable. What's going on in the Karen Reed case with all these officers being disciplined, dealing with the Canton cops acting like a couple of untrained bumpkins, scooping things up in cups and leaving in a plastic bag from Kroger or paper bag from Kroger. No, none of this case makes any sense so far. So don't sit there and act incredulous about it, Cosgrove.
Or not, or has an impression of you have an impression of his ethical qualities. But he would have to be both unethical
Thank you, Bob.
and stupid to both engage in this kind of jury tampering, and there's nothing else you can call it. And
okay, and I'm not going to stop every 5 seconds, chat, but he'd have to be stupid. Well, Lally doesn't strike me as a smart guy given how he presented the last case. But also, it wouldn't be the first time that government officials break the law. Like, let's not act like that doesn't happen. You know, if you're Michael Proctor, you'd have to be fucking stupid to act the way you did and piss away your 75 grand a year job with a guaranteed retirement and easy street. You'd have to be stupid to do that. You'd have to be stupid to do a lot of things. You'd have to be stupid to act like Trooper Bukkake. You'd have to be stupid to believe in Trooper Paul in his crash reconstruction. There's a lot of stupidity running around.
Essentially, contacting a juror to fix the outcome of the jury trial, and then turn that information over to a woman who is a known YouTube blogger. That's one. In item 7, she indicates that she, Ms. Peter, is paid $1,500 each month via Cash App for her assistance in the Karen Reed and Aidan Kearney prosecutions. Well, I'm tempted to make light of this, Your Honor, and say that if the district attorney is paying Ms. Peter that money, he's not getting his money's worth, because I haven't heard from Ms. Peter in the entire time that I've been representing the Commonwealth in this case. But put that aside.
Yes, I mean, are you Boomer Boy? Are you on Twitter? Are you out there and looking at the protests? Like, where you're telling me you don't know about any of this? You don't know who she is? You don't know what she's doing? Really? Like, you're not telling me there's a concerted effort out there? Girl, come on now.
Cash App has records, as I understand it. It has records from what bank account to what bank account. I don't know what Mr. Bradle did to verify this, but I don't see any records from Cash App, and I would like to examine Ms. Colantonio, excuse me, so far it's still impounded, but I guess I've been about the 9 millionth person to let the name out of the cat out of the bag.
And I move that it be stricken.
Okay. Go ahead, Mr. Cosgrove.
I would like to examine the affiant as to that information and what, if anything, that she did to verify it. The affiant then says that she personally has heard Ms. Peter on the phone with Hank Brennan, that she personally recognized Hank Brennan's voice, that Peter told him that her people leaked it to the media.
I was about to say, when he said she, yeah, I'm like, and he agreed to the impoundment of all this. So it's like, yeah. Yeah, don't worry, Turtle Boy. I'm sure the court will get to holding them accountable at some point. Maybe.
Referring to the federal investigation being over. Well, I think the people who, putting aside the fact that I think the person who leaked it to the media effectively was the U.S. attorney on a radio interview, who responded to the question of whether she had communicated with the Commonwealth and the police department as to the progress of that investigation, by saying that she couldn't verify whether a grand jury investigation was over, but that it would not be uncommon for her office to communicate with law enforcement, et cetera, et cetera. Anyone who had any sophistication knew what she was saying. And about a week later, the district attorney's office verified in open court that that was the case. So I don't know why we needed Ms. Peter to leak that to the media when we were announcing it in open court, but at any rate, it's in there. I would like to examine the affiant as to how she knows Mr. Brennan's voice, how she knows about these multiple conversations, when they took place. And finally, I'll skip over the rest of them for the most part.
Real quick, Vanessa, when I say I'm paying the water bill, I mean I'm going to take a leak. Like, if you're joking, that's great. If you're not joking, I just want to make sure you know I meant like I have to take a potty break, so I'm going to pee. So I just want to make sure you know what I meant.
But I come to items 14 and 15, in which Ms. Peter informs her that Jennifer McCabe bought her a brand new sectional, I assume she's referring to a sofa, as compensation for her assistance. Not quite sure how Ms. Peter has assisted witness Jennifer McCabe, but maybe it's revealed in the next section where section 17, where Peter informs her that Jennifer McCabe paid her for her show of support. Well, subsequently know that apparently the affiant lives in the same apartment building of Ms. Peter, who has not denied in her own posting that she knows this particular witness, and presumably she knew that Ms. Peter had a brand new sectional.
Well, there you go. I was waiting for him to say, how was he, when he's saying she, he meant Kate, but once again, he's outing identities of the source, the affiant. So remember, chat, you can't, you can now verify things. Well, now we know it's a woman, and it's a woman. Now he just said where she lives. He just, not only that, like that's even worse. Saying gender of somebody's information like a protected witness. Okay. Hey, here's where they live. Whoa, buddy. That's.
I suggest that the information that Jennifer McCabe brought her a brand new.
Oh, he did say her last name earlier?
Is made up as.
I must have missed it, but now he said, well, now we know her last name. We know she's a woman, and we know where she lives. That's pretty easy to figure out now.
Out of whole cloth. And I'm not going to go through it all because I'm hoping the court will give me an opportunity to examine this witness on the witness stand. But I think the court could ask itself why this particular affidavit is being submitted now in support of what I would suggest would otherwise be.
I think I understand, Bob, this is actually pretty important to go through. Listen to how the state is handling this. This person, they agree, we're not going to talk about them, and they're trying to blow it all up and sabotage it. I do think it's very important to get through this, just because it is important. I mean, it shows you not only just the constitutional violations, but just the scumbaggery and just, how the state's just full of just a bunch of rats. Just a bunch of gnawing rats.
A fairly routine thing that comes before judges, motions to compel discovery.
Okay. Let me hear from Mr.
And then,
I'm sorry. I don't mean to cut you off.
And I suggest that the reason is this, and the court can make its own judgment. And my assessment is that the purpose of the motion is to dirty Jennifer McCabe. I don't think it's an accident that Jennifer McCabe was testifying today in the other courtroom and yesterday in the other courtroom.
But the juries don't know. They aren't watching.
The purpose of this motion, which has been loudly trumpeted by Mr. Kearney on his YouTube show, was to accomplish his oft-stated purpose of prejudicing the jury in that trial.
So what?
Let me just talk to the attorney.
Oh, so the judge is going to take it off to the side. They're out to the side here. We're going to see. We'll skip along.
Mr. Cosgrove, the floor is yours.
At
Okay.
this point, unless Your Honor has questions.
That's fine. All right. Mr. Bradle.
Thank you, Judge. So, Judge, a lot to respond to. First of all,
why was that affidavit attached to the motion to compel?
Because, Your Honor, that's the basis to show that this information exists. The Commonwealth has not provided any of those things related to Kate Peter. And my colleague, Mr. Betterer, who I know is watching here from New York, he wrote a letter to counsel for the Commonwealth in, I want to say, October of 24. That was the first of his 3 letters that he wrote, pointing out all kinds of these things. Ms. Peter has been under oath at other hearings, my client's restraining order hearings against her, where she has said under oath that she's cooperating with the Commonwealth. She has said it many times online that she's cooperating with the Commonwealth. To this day, our third motion to compel, discovery orders, the discovery was due a year ago, Judge, and we still have nothing. And so this woman came to us, Judge, April 21, Patriots Day, came to us Monday, April 21. And we did what a lawyer needs to do in that situation, which is we memorialized it, she signed an affidavit, and we submitted it as further proof
blabbing about her
upon Mr. Bettero's letter that this information exists. And now we have it from the horse's mouth, Your Honor. So that's the answer to your question. This woman is saying to the affiant that she is working with the Commonwealth, giving all these details about.
Now, was Turtleboy, you don't have to answer this question, but was Bradel referring to Kate as a horse intentionally or not? Just curious.
Making money, about meeting with these people, about receiving funds. A lot of this has been corroborated by other people on the internet as well, Your Honor, which we're in the process of gathering up. But this affidavit, Judge, was submitted for Mr. Carney. It's got nothing to do with the Reed case. It has information in it that's important to the Reed case. We are not the Reed case. I am here today defending Mr. Carney from these scandalous allegations that just absolutely seek to destroy the First Amendment in Article 16.
Okay, so what's the discovery that you want compelled?
So, Judge, I want all the information from this affidavit and from our motion to compel about Kate Peter. She's a government agent. If this is all true, Your Honor, the DA's office is paying a third-party witness to intimidate witnesses in the Karen Reed and Aidan Carney case.
So what? Maybe we should hold a hearing on that. Okay. So I'll take this under advisement.
So we're going to get a hearing on that.
I'll come up with an order as to how we should proceed on that.
Thank you.
Now, as to Mr. Cosgrove, are there any other issues that you see? Any other motions that you want to bring to my attention? I know that I received a thumb drive earlier today that I've had a chance to review, and I'm sure Mr. Bradel has a copy of that.
Yes, I provided Mr. Bradel with a copy when I saw him earlier this morning. I don't know that he's seen it. I would like to play it for the court if I could.
Yeah, no, you can play it. So, Mr. Bradel, this is Mr. Cosgrove's motion to have your client's bail revoked, I guess.
Yes, Judge.
Okay.
And the idea that it happens the morning of, like you're walking into court, and I've had this happen before. Prosecutor hands you, hey, I'm trying to fuck your guy in the ass today. Do I get a nope? Hey, you're Mr. Martin. We need to do this right now. Yeah, that's you hear Hank Brennan crying about trial by ambush. It's not fair. It's not fair. Well, what is this fair? Is this fair to Turtleboy? Funny, like once again, Hank says funny how that is. Yeah, it's real funny how that is. It's funny how that is here.
If I may, Judge.
Well, I'm going to start with Mr. Cosgrove, and I'll go over to you.
Thank you.
Go ahead.
As Your Honor may know, I'm pretty much a computer illiterate, but fortunately, advocate has stepped into the breach and helped me out here.
The advocate, okay, boomers with their technology.
Mr. Bradel, you want to come up? Sure.
All right, so guys, this is Turtleboy. That thing they quoted. This is it right here. They're trying to show. So we can't hear it. I'm just gonna skip ahead. Oh, actually, here we go. I'd be very happy too. You guys can't hear it? All right. We'll skip ahead. Yeah. Sorry, guys. I don't think anybody could hear it except me, but I got good headphones on, so.
So for the record, Your Honor may or may not be aware that Nicholas Marino is another trooper in another.
Yeah, I was on, who is that? Tell me who Garino is.
He's a trooper in the Karen Reed case, and he's an electronics expert that's did the analysis of the two devices of Mr. Kearney's that were already searched, and that aren't really the subject of this whole tainting thing, and also did the analysis in the other case that he mentioned and has been defamed as supposedly missing all kinds of communications, which is not true. He was, as is alluded to, in an unfortunate car accident that you hear Mr. Kearney taking pleasure in. So, let me start with a couple of things,
Yeah,
Your Honor.
taking pleasure doesn't sound like a threat.
Yep, take your time.
Having had to put this together at the last minute because the presentation just came to my attention the other day, I didn't have directly in front of me the orders that Your Honor entered, although I think I summarized them correctly in my memorandum. But as I understand it, according to the docket on March 5th of this year, after I initially brought this to Your Honor's attention, the docket entry records that the court orders defendant to have no contact, direct or indirect, through third parties with any of the witnesses or victims in this case. And two,
that is a fair argument. You don't control what arouses you. Fair enough. We don't get to control our kinks. Our kinks chose us. Very fair, Turtleboy. Oh.
stay 100 yards away from any victim's residence or place of work. Defendant assents, bail warning read. Now, as I recall, that was sort of a provisional order, and at that time, even more so than today, I had just got the information of relative to Mr. Kearney's antics outside D&E Pizza in Canton. Mr. Bradle hadn't really had time to absorb it. I didn't have police reports to give him. So Your Honor may remember that you put it over to the following day for hearing. After hearing that day, the docket reads as follows: additional conditions of release. 1, stay away. No contact, direct or indirect, with the named witnesses in his superior court cases. 2, stay 100 yards away from D&E Pizza in Canton, Mass. 3, behave in an appropriate manner while in any courthouse or within 300 feet of the building. Defendant assents, bail warning read. So with that clarification, Your Honor, I'd like to begin. We indicted Mr. Kearney because in our view, he was engaged in a campaign of intimidating the witnesses.
No, he wasn't.
After we indicted him, one of those methods he essentially ceased, and that was leading parades of automobiles outside witnesses' homes and places of business.
Still not illegal.
But he did not otherwise decease. So what we have here, Your Honor, is the most extreme recent example of Mr. Kearney's behavior. And if I wanted to bring these to the court's attention, I could probably do it about 4 times a week. But just to give you some other examples, if I might, of Mr. Kearney's latest hits.
Go right ahead.
Within a week or two of the last time I brought his behavior to your attention, he was on a live broadcast mocking Elizabeth Proctor, a witness in the Reed case, for thinking she...
God, he clears his throat more than I do.
Mocking Elizabeth Proctor, a witness in the Reed case, for thinking she was blue, unquote, or a member of a blue family, because family members were police officers and because
Okay.
she gave oral sex to her husband, who was a police officer. And he went on in the oral sex vein for some time.
Okay.
One can imagine the effect that that has on a witness, knowing that she's being humiliated in front of hundreds, perhaps thousands of people.
So what? Women suck guys' dicks. Like, is that a shocker to everyone? She probably does blow them. Like, I mean, like, getting humiliated, like, fucking suffer. I mean, that's what we're down to. Well, it's like, I'll call them all cucks. There, that's it. They all like standing there watching their wives get fucked in hotels by other men. How about that, Mr. Prosecutor? Is that humiliating? Is that humiliating? Once again, Lake County, Ohio. Serve that fucking warrant. Let's go, homie.
Objection, Your Honor. This has been dealt with by the court.
Yeah, he's given me some history, so it's overruled. I'll listen to your recitation.
I informed the court the last time, and the court viewed it, of his show up and antics before the Albert's Pizza Shop. I have personally routinely heard him refer to the presiding justice online of the Reed trial as a cunt. He engages in constant defamation, for example, of Jennifer McCabe as a murderer, and he has described the others as murderers.
Bob, we're going to need a lot of commissary money for me if that happens. I'm going to need a lot of commissary, chat. But, you know, calling these women cunts, I'm pretty sure that's been established to be correct. All the Daniels and the Alberts and McCabe's, yeah, they're all cunts. We established that after the first trial.
And in general, he is aware and has remarked, I think this is another thing I brought to Your Honor's attention the last time, has remarked with satisfaction that the results of his broadcasts have made it difficult for these people to go out in public without being harassed and without being mocked. I would suggest that Mr. Kearney wanted this communication to be conveyed to Lieutenant Tully, knew to almost a certainty that Lieutenant Tully would see it, wishing death in the most horrible fashion to him and his wife, and knew that that would excite others of Mr. Kearney's followers to pile on, so to speak. I'd like to introduce an exhibit, Your Honor. I provided a copy to Mr. Bradel.
Wait, he forgot about Tully's little retarded children. Not only harming, remember, I thought Tully and his wife were scared. What about their little retarded kids? But still, what's the problem? What's the problem?
I'll give him an opportunity to object, but I would suggest it could be marked for identification.
Yeah, we'll mark it for identification.
And,
you could just give it to Soraya. Okay.
I do object, Judge, based on relevance, materiality, foundation.
You should give it to Soraya. Okay.
Thank you.
All right.
And just so we're clear, Judge, I don't even think the Commonwealth is suggesting this has anything to do with Mr. Kearney sending that. Which, of course, he did not.
Well, I'm happy to agree with what Mr. Bradel...
We'll mark it for ID, Soraya.
With what Mr. Bradel just said, Your Honor.
Okay.
But it is always Mr. Kearney's response that when these witnesses are deluged with harassment immediately following his broadcast and thereafter, that, of course, he had nothing to do with it. He didn't send it. But he knows what happens. And I would suggest to you, Your Honor, that this is relevant, not because Mr. Kearney sent it, but one, because the court could conclude that it was a logical outcome of the kind of scorn and hatred poured out upon Lieutenant Tully and his family. And two, that Mr. Tully, Lieutenant Tully, who is well familiar with these reactions, upon reading or listening to,
he's familiar with those reactions. How does that work?
Mr. Kearney's broadcast, could reasonably fear reactions from these sort of nuts directed at his wife and family. And I suggest that his reasonable fear is evidence of intimidation of a witness.
There is no reasonable fear. There is no objectively reasonable fear here. There's not even subjective fear. There's no objectively reasonable fear that some guy talking about how your wife's some sort of whore is going to be a threat. Or that people hope I die of a heart attack. Is that a threat? You know, like, God, if this is a threat, then shit, man, I get threatened all the motherfucking time.
And on that basis, Your Honor, I would ask that it be marked as an exhibit.
Yeah, we'll mark the disc as the next exhibit.
And I would further ask that it be impounded because I don't want the comments made in that out there to give any other people.
Yeah, I'll impound it.
Encouragement.
Margaret, is the disc. Yeah. Yeah.
So I don't want to belabor this, Your Honor.
Can I just go back with you, Attorney Cosgrove?
Yes.
As to Exhibit A, could you explain that to me a little bit more?
One you just marked?
This one right here.
Yes. At about whatever time is indicated on the top of the email, I received that email from Lieutenant Tully indicating that he had received that communication from this person, who, so far as I know, is unknown to all of us. Whether his identification is genuine or pseudonymous, I have no knowledge, and that he received it through LinkedIn. And that's about all the background that I can give, Your Honor.
To your knowledge, though, this says, well, strike that. What's the relation?
To my knowledge, I do not allege that Mr. Kearney personally sent it.
Okay. I guess that's what I'm
I
asking.
allege, number one, that it may well be, one could infer reasonably that it is the result of Mr. Kearney's broadcast.
Okay,
He provoked
I get
it.
you.
And two, one could infer that Lieutenant Tully reasonably anticipated these kinds of responses. You know, I don't know if this nut is going to be motivated to go out and try to assist in a car accident or in
Fucking
burning things
kidding
down.
me.
And
Bullshit.
you know, when somebody
Absolute bullshit.
when somebody says to an audience that Jesus told him,
Jesus spoke to me and he says you need to fall down a flight of stairs and break your fucking neck, Mr. Prosecutor. Does that mean it's going to happen? Am I going to waddle all my way on out there to make it happen? Like I said, start writing them warrants. Start writing them warrants, brother. Let's go. Let's go. Fucking the thinnest of skinned bitches out there, man. And, you know, Mark Antony was right, man. Ambition should be made of sterner stuff. I mean, these guys, like, how... I can't imagine criminals get arrested in Massachusetts where Tully is working on cases. God almighty. Like, has he ever had to deal with real criminals before? What a paper-skinned bitch.
wants revenge. How does that play in revenge in the form of somebody being?
I mean, that's really bad considering I've talked about how to sensitize fertilizer and do all kinds of really, really glowy stuff before. But yeah, Bob, that's a bad thing for me, especially if you're on locals and we watch like how to make explosives. Like, yeah, I'm on a little bit of trouble. Uh-oh.
Burnt up in the most painful way. Mr. Kearney expresses concern that I gather what Lieutenant Tully is supposed to have done to his children is arrest Mr. Kearney on one occasion pursuant to a warrant.
Oh, and Prosecutor Cosgrove, or 88 Cosgrove, I'm sitting here assembling a Beretta 92. You could probably hear me doing a clicking and clacking. Is that a threat too? I don't know. It's up to you.
At the bus stop after Mr. Kearney dropped his children off, if Mr. Bradle had looked at the discovery that the Commonwealth turned over of the body cameras of the arrest, he would observe the officers carefully waited for the children to get on the bus and be on their way before their father was arrested.
Exactly.
But yet,
just hurt feet.
this is continually held out as a crime, while at the same time Mr. Kearney has no compunction about wishing death on Lieutenant Tully's children and wife. So, Your Honor, I make those two arguments. One, that this was posted with a sure and certain knowledge and intent that it comes to Lieutenant Tully's attention. Which
how do you know that? How do you know that?
And two, I make the point that a no contact order means no contact. The content, before Your Honor hears the First Amendment argument, the content of the contact is irrelevant as far as whether there was a violation of the order. And I'd just like to call Your Honor's attention, if I can do it, to a case that I cited in my memorandum to Your Honor. I believe I cited it for
none of this is contact so far.
O'Brien versus Sparowski.
None of this is contact.
461 Mass 14.
None of this is
in the course of
contact.
that case, the court refers to the Cho case on page 424 of the opinion. And it summarizes that case as follows. The defense.
They're just letting him, he's just, Bob, I know we're getting to the Tim Bradel part, but God, we're running out of time. Is he going to just whoop ass in like 10 minutes? That's going to be impressive, but I was hoping for a little more foreplay because hope it's a little longer.
And then produced flyers with the word missing printed in large type across the top, between which was a photograph of a former girlfriend who had broken up with him and offensive sexual remarks about her.
Okay.
He then hung the flyers in several places in her high school. He was convicted under a statute which criminally punishes persons with offensive and disorderly acts of language accost or annoy persons of the opposite.
Oh, I bet she can.
We, that's the appeals court, concluded that the defendant's criminal conviction for this communication did not violate the First Amendment because it was a true threat that had no expressive purpose, but was instead intended to get back at the victim by placing her in fear that she might suffer some sexual harm or wind up among the missing. Your Honor can look a long time, I think, at the language of Mr. Kearney's message in an attempt to distinguish it from the Cho case in terms of the language having no expressive purpose, but instead being intended to get back at Lieutenant Tully by placing him in fear that he or his family might suffer some harm. In fact, what other meaning are we to draw from revenge? But apart from that, Your Honor, even if there's some far-fetched First Amendment phrase somewhere lurking in this message, the other material is not protective, and the violation of the order does not consist of the language, but simply the context. Now, the other string in my bow, Your Honor, is the argument that this is, again, a violation.
How? How is this a violation?
With the statute.
How is this a violation? Still don't know.
Mr. Kearney and I have gone back and forth on that statute and how it should be construed and how it should not be construed. Your Honor currently has it under advisement. You see my arguments in my memorandum here with respect to this case. I won't belabor them in oral argument. So I will rest at that point.
Okay.
And let
Mr. Bradel, tell me about that word revenge and how.
Okay, guys, here we go. It's Tim Bradel's turn. I kind of get the feeling if I was up there, it would look like this, but I'm sure it's going to be a lot like this from Bradel. Might want to turn your sound down just a little bit in like 2 seconds. Turn down now, but you got like 2-second warning. It's going to look a lot like this. I'm pretty sure Bradel's going to sound like that. So here we go. I have not heard Bradel's response. I heard up to that and I stopped.
Am I supposed to interpret that?
Judge, this is not a threat. This is not contact. This is satire. This is all protected. I am so sick of having to come before a court because of Norfolk County and talk about speech that Norfolk County
Argue to
doesn't
me,
like.
not to anybody else. Just tell me about that word, revenge.
Revenge. Excuse me 1 second.
Yep, no, take your time. You can confer with your client.
Yeah, you know, it's all satire. It's all commentary. As far as
My client is allowed to have hopes and desires and wishes that you or me or Mr. Cosgrove don't agree with their own life or are repelled by. You know, why do we keep having to come back here? I don't know what it must be like to wake up on the wrong side of the First Amendment every day. This is protected speech, Your Honor, over and over again. The Supreme Court has spoken for decades and decades. Brandenburg, Watts, Shaplinsky, O'Brien v. Borowski, Welch. Judge, this is a waste of this court's time. This is intentional infliction of emotional distress on my client. The Commonwealth has been rebuffed over and over and over on this exact scenario. He is not contacting a witness. He is not threatening a witness. He is talking about someone who has destroyed his life, Your Honor. He is allowed to lash out back. And the First Amendment grants every declarant this room to talk without fear, without the kind of fear that this county has inflicted on Mr. Carney over and over and over again. And it has to stop, Your Honor. This is First Amendment protected speech. I don't care. We don't like it. I don't care. It doesn't matter. He is not threatening Tully. He is not contacting Tully. He is a reporter with his own style of satire that is addressing a large audience, and he is doing a major service pointing out over and over and over again corruption in this county, perversion of the First Amendment, abuse of the witness intimidation statute, Your Honor. This has got to stop. I don't want to come in here anymore and pretend like, gee whiz, this is a close call. It's not, Your Honor. This is First Amendment protected activity that the court, I have every confidence that this court is going to vindicate. This cannot happen over and over again. I get a motion to destroy my client's liberty 3 hours before every single time they want to do this. I get communications, oh, we're not going to try to revoke his bail. Then I go to Stoughton, they want to revoke his bail. What are they doing? They're corroborating the affidavit we talked about 5 minutes ago, where Jennifer McCabe said, I'm not going to test interested in that. I'm interested about the word revenge. Judge, he can say.
Okay, like just revenge. But if you're focused on the word revenge, Judge, the revenge then flows into what he said. So I don't see how you could focus on the one word. But Brado's doing a great fucking job. I'll leave it to him.
A revenge. He hopes it's revenge on a bad guy that's been destroying him. We cannot engage in this kind of content-based viewpoint discrimination. We don't have to like the viewpoint, but like Voltaire's biographer said, we have to defend to the death his right to say it. And that's all this is, Your Honor, over and over again with this. Excuse me 1 second, please, Your Honor.
Yep, no, take your time.
Truth is treason in the land of lies, chat. I forget who said that, but truth is treason in the land of lies.
And Judge, in this context, to address your question, in this context, Judge, revenge means karma. He's not saying, I'm going to go get revenge on you. He's saying that karma's a bitch, is what he's saying, Your Honor. And he's allowed to say that. And this isn't something that is intended to be played on a judge's bench in the formality of the courtroom. This is something that he is talking to his viewers online. And he's allowed to do that, Your Honor. So we have got to stop the charade that this is somehow, gee whiz, we got to lock him up because he's talking and satirizing, engaging in political hyperbole, protected by Watts, Brandenburg. The only thing he can't say are true threats and fighting words. We all know that 100 times over. Why are we here, Your Honor? I ask that you deny the motion and just please issue a ruling that settles this issue once and for all, that this has a chilling effect, Your Honor. Every time we're here, how many journalists do we have in this room?
Okay, I'm up here. Director remarks to me, not to anybody else.
No, I'm just looking to see if there's...
No, I'm up here.
There's journalists cover this case. They are experiencing a chilling effect. Am I next? Is the Commonwealth going to go after me next? How far can I go? Can I show up at someone's door and knock on the door? Oh, did I intimidate somebody? Is Norfolk County going to go after me? We don't know. We don't know what they're capable of. And Your Honor, you're the bulwark here. This is the First Amendment we're talking about. We're kicking this around like it's some city ordinance.
Okay.
Thank you, Your Honor.
All right. I'm going to take it under advisement. Mr. Kenny, please stand up.
I mean, there's nothing else to say there. That was brilliantly done. That was brilliantly articulated. Yes. They can't come and fuck with somebody and they get mad somebody's going to say this is bullshit. You can't put someone in jail, slap them with felonies, and threaten them with prison, and let him just go, woo, 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 woo. Like, you are allowed to talk shit about him. Now, is it advised, ill-advised, good advice, bad advice to do it? Separate matter. You have the right to do it, and you should be allowed the right to do it. And more importantly, Turtleboy's in a special position because he's in a situation where he's fighting against these institutions and doing it as part of the part of a civil society. You know, he is operating as one of the most critical estates we have. You know, this is the idea. Like, he's not. You know, I mean, he's the fourth estate, and he's fighting against the government. Like, what else can we do? What else can we do here for him? Like, that's all he can do. That's the fourth estate. I almost said the fifth estate, and I'm like, wait, that's not right. Had to catch myself. So, this is just, I don't know. Let's hear what the judge says. You know, like I forget who said. Hold on here. Truth is treason in an empire of lies. Who said that? George Orwell. The truth is treason in an empire of lies. I think it might have been out in 1984, but yeah. Here we go. User is saying, is he Thomas Paine? No, but he doesn't have to be. And at the time, Thomas Paine was just a random fucking guy too. That's the point. Thomas Paine didn't mean shit until history put its eye on him. While he was alive, he was just some dude writing. Really, at the end of the day. So I don't think that's actually a proper way to look at it. And ultimately, it doesn't matter. You know, anybody who goes out and talks about something, you're doing journalism in a way. Right now, I'm doing journalism. So, in the land of sandwiches, the baker is king.
You're walking on kind of thin ice. I'm going to review everything and I'll come out with an order. But I take what Mr. Cosgrove has presented very seriously. I also take into account that there are certain First Amendment rights here as well. And then the issue is always, how far does the First Amendment take you, and when does it become intimidation of a witness? The word revenge, some of those other words that are on that tape are getting very, very close. So I'll take it all under advisement. Let me just see the lawyers at sidebar. Thank you.
And here's the thing, that right there, he's not advocating for imminent lawless action under Brandenburg. But he's also not like in Hess v. Indiana, where he was like, we're going to fucking do it right fucking now. I mean, even if you were to take those as a threat, it's some time in the future at an unspecified date. So therefore, under Hess, which is still valid case law in the United States, this still wouldn't qualify. I'm not saying it is, but let's say in arguendo, that was the case. It doesn't work. It doesn't work regardless. But yeah, he's on thin ice. Like, no, he's not. That ice is still thicker than the fucking skin on Tully. Yes, thin ice ain't broken ice, too. Yeah, and now Turtleboy's walking on eggshells, which is bullshit. Which is absolute bullshit. So. Well, anyways, it looks like a bunch of people have shown up in the meantime. We're going to go through some of your guys' comments here and some of your questions you guys had. Guys, if you guys are new, my name's Sean, potentially criminal. I'm a defense attorney in the Cleveland, Ohio area. And yeah, we were just kind of covering what's going on with Turtleboy since, you know, this is part of the Karen Reed saga. Not to say his saga is not important, but it is kind of part of the greater story. Let's see here. Ag, I would say, what would I tell Turtleboy if he was my client? I mean, in this situation, as long as you're, what are you willing to do right now? I don't know what the judge is going to do, but I'd say it's up to you at this point. Turtleboy is sophisticated enough to understand what he's getting into and what he wants to do here. And whatever he does, I'd be willing to help him fight for it, but it's up to him. It's really up to him what he wants to do. So, you guys, the ice isn't thin if I walk on it. Yeah, thanks. And also, real quick, guys, if you guys are here and you guys are new, I did want to give a shout out to our show sponsor tonight, thedragonstreasure.com. It's a haven for tea lovers, coffee lovers, and soap lovers. I mean, I think we all love soap. I hope we all love soap. And if you don't love soap, get right with God and start using soap. Guys, over at thedragonstreasure.com, use the promo code criminal. You get 10% off your order. Guys, T-Man is doing really good. His site's been doing gangbusters. Ran a little bit of a hard patch, it sounds like, lately. Show him some love out there. Order some tea, order some coffee, order some soap. He does do international shipping as well. Take advantage of that. Promo code criminal. Thank you. Just for that. But let's get to some of these comments here. All right. So, and also I want to thank Mike over at the Young Jerks for allowing me to use his stream of the hearing. I really very much appreciate that. So thank you so much out there about that. Yeah. And that's the thing. They're hell-bent on putting him in jail, and he's got to worry about himself and his family. And that's where I would tell him, you're going to have to do the math on this. Are you willing to do this the whole way through? And if you are, great. If you're not, great as well. I understand both options. So it's really tough. It's not an easy answer. It's not an easy answer. Shugi Show is saying, late and still a penny lawyer foamer. Well, thank you, Shugi. Sleuthy is saying, yes, the dangerous thing about the anti-Karen Reed people is the anti-Karen Reed crowd is dumb enough they might set themselves on fire to prove a point. Surface says Judge Bev is the queen bitch. I can see that. I can see that. Jefferson Post says this is Trump's mean tweets territory here. Yeah, it is. It is. And as Turtleboy said earlier, this is a grown man with a gun and a badge, trained to protect us from bad guys. I know. Imagine that if there are real bad guys out there. Bad guys like a gang. We're going to fucking kill them. Do you think Tully's going to cry and hide? Well, probably. Imagine if he had to fight real crime. What would happen? Like the state government of Massachusetts would collapse. Crystal is saying, I am so ashamed to be part of the Commonwealth as a South African. Well, remember, the Commonwealth, this is not part of the Commonwealth in that sense, like the British Commonwealth. Like there's that Commonwealth. We don't, there are some states in America, they're considered Commonwealths. So like there's the Commonwealth of Virginia, the Commonwealth of Pennsylvania, the Commonwealth of Massachusetts, the Commonwealth of Kentucky. For example, there are other states, the state of Ohio, the state of Indiana, the state of Illinois, the state of California. And then you get to things like, the state of Rhode Island and Providence Plantations, although they removed that part right now. So the Commonwealth is not like part of the Commonwealth you're thinking of. But I do, this is, as an American, I'm ashamed to see this going on. As an American, I'm ashamed to see this going on. Nice podcast, stupid. How you doing, Dan? Saying Turtleboy's based. Thanks for doing what you're doing. Well, thank you, but I'm really talking about what's going on. Turtleboy's doing the real work, so I appreciate though. Crystal gifted 5 subs out there, chat. Guys, if you got something from her, please tell her thank you. I know she'd appreciate it. And Crystal, thank you for your support and your generosity all the way from South Africa. Thank you. Turtleboy, having an audience doesn't make everything I say in direct contact. I know. Does that mean everything I'm saying is in direct contact with Tully or Cosgrove? No, nobody would ever make that argument. Now, if I set it up where there's like, I want you to go talk and like we have an outline of people, that would be in direct contact. But merely just saying these people are assholes, no, that is not indirect contact. Sleuthy said, when someone was actually abusing, harassing, and intimidating me, I stayed as far the fuck away as possible, never watched his online activity, and made sure I was never where he was. These people do the opposite. I know. Turtleboy showed up outside a restaurant, people tried to fight him. Isn't that funny how that works? Yeah, so scared, and they're always there. Cat, but Cat not Williams. Guys, if you guys are looking for good content out there, Cat does a great job. Gifting 5 subs of her own. Thank you, Cat. I appreciate your support. I can't remember. It's been a member for 5 months. Thank you. Is saying, oops, I think I bought it. Kate B says, Turtleboy put the fence because he's a liar. Kate B, go read Ohio v. Reiner. You'll learn a lot. Oh, that's free tip for you today. Go read Ohio v. Reiner. Ohio v. Reiner. Maybe you'll learn something. Eric Foam says, I understand. I never understood why people keep old phones. I have a bunch of old phones. Open one of the drawers in my bedroom. It looks like I'm running like an Al-Qaeda bomb shop out of it. I'll hold on to them. KRM says, this is your reminder to use encrypted messaging, folks. Signal is a good choice. Yes, but also making sure your Signal's set to like very short time windows of message retention. That's the other big thing. Yes, Turtleboy's like, maybe with my old phones, they can take Peyton Manning out of my lineup. Patty asked a great question. How could Turtleboy have protected himself here? The only way they're going to leave him alone is if he stops. So there's, and I know that's not something he's going to do. That's the only way they'll leave you alone is if you quit. They want him to quit. They want him to shut up. And if he shuts up, they'll leave him alone. That's what they want out of him. So there is no, the only way, what they want out of him is him to quit playing the game. That's what they want. So, there's no way to protect yourself against evil, corrupt men coming after you. When you're in a strange land and ruthless men seek your life, there's no way to stop that except flee. And he's not going to do that. And I don't blame him for not. Let's see here. Laura is saying, too many idiots are blind about how they may feel about Turtleboy. And she said, I'm a big fan personally. Well, to be fair, I will admit, and I think I've said this a lot. I knew Turtleboy from a different saga. I knew Kate Peter from a different saga. And a different little story, a different storyline that ran through. And I had my own preconceived notions about Turtleboy. And I was 100% happy to know whatever that was in the past, I was wrong on. And I'm happy to be wrong on that. I'm happy to admit, yeah, I let that cloud my judgment. It's too many people are blind to understand their rights are being trampled on. Yeah. Yep. And given how the police act in Massachusetts, and especially in the Boston area, and given how the DAs act in that area, it wouldn't surprise me if there's another type of Karen Reed situation again. Jim tells you, says, what the fuck is this Soviet Russia forcing him to turn over his passwords? Well, they want him to access it. So, that's not uncommon trying to force it. Oh, hold on one second. We are dog sitting, and one of the dogs is barking really loud. Misanthropic Android. It's good to see you. It's been a little while. Says, would a pattern on your phone be protected by the Fifth Amendment? So yes, like Face ID, not protected. Your fingerprint, not protected. But if you have a code, that's protected. But a pattern is also protected because you would have to tell them how to do the pattern. So that would be protected as well, because I would have to tell you the code. A fuzzy creature for $5 says, I wish more people understood how corrupt Massachusetts is. Understandable. Yeah. The Departed is surprisingly partially a documentary. The Defense Diaries podcast says, don't forget to smash the like button, everybody. That's right, chat. Bob and Allie over at the Defense Diaries covering the Karen Reed trial, among other things. They're a great team, husband and wife of attorneys. They do great stuff out there. They do great content. Bob is saying, constitutionally speaking, Aiden's case is far more significant than Karen's. It is. It is. At the end of the day, I've said this before, if you guys are new, Karen Reed's case is a DUI case. It's a DUI case where it's a aggravated, like in Ohio, this would be an aggravated vehicular homicide. Really. It's a case, it's a DUI case. Okay, she was drinking, but did she hit anybody? Really is what it comes down to. So, but yes, Aiden's case, this case here, Turtleboy's case, the constitutional implications are wider sweeping, are far more important in that regard. And they're weaponizing the statutes to shut him up. And it's absolutely fucking crazy. Yes. Project Calm is saying, so in this jurisdiction, the district attorney is a defense lawyer. Well, remember, they brought in Hank Brennan because they realized they couldn't make it work. They realized none of the horses in their stable could win the race. So they went and brought one in from the outside. That's why Hank Brennan's here. They had to bring in a ringer. They had to bring in out-of-town help. So that's why that happened here. But anyways, he believes the federal prosecutors have too close a relationship to the defense and thinks the defense attorneys can launch a criminal inquiry. Yes. That's all part of it. The same county. Yep, the exact same county. Jim Cox says for $2 for the water bill. Thank you. Catnut Williams gifting 5 more subs. Crystal gifting 5 more subs. You guys just on fire tonight. Thank you guys so much for your support and your generosity. I truly appreciate it. And Chad, if you got something for them, please tell them thank you. KRM says, hold on, chat. I gotta close the door. All right, let's try that. Maybe it'll be a little quieter now. Sorry, guys. KRM says, yes, this is how incompetent the government is. Well, is it incompetence or maliciousness? I'd argue at this point it's more malicious than anything. We're past the point of incompetency, I would argue. Guarino got hit by a car. That's fair, Turtleboy said. Yeah, I hope it fucking hurt like hell given how he did things. I hope it hurt like hell given how bad he fucked with the Sandra Birchmore case. And this case, I hope it hurt. I hope it was excruciating. It's not like Turtleboy ran him over. I know. Bob in the defense race says they're revoking my bail. Yeah. Not so Goodland says the prosecutor was in the yes, Cosgrove was around for the Salem witch trials. It sounds like it. He's so old, it sounds like he's crying half the time. You know, when people get real old, they start having that cryy voice when they're talking. And Bob is saying, yes, the real reason that none of them will sue Aiden is because the discovery would be epic. Yes, well, the other reason is they fucking lose. So they're using the criminal justice system to batter and beat him. Because if this was a regular lawsuit, he could talk all he wanted. And yes, the discovery, getting access to all their information. But remember, a lot of these witnesses, what happened in the Karen Reed case? They go, oh, I threw away my phone. Oops, sorry. Well, guess what? That's spoliation of evidence. That allows for an adverse inference to be read in court saying, ladies and gentlemen, they threw their stuff away. You are allowed to presume that stuff would have been detrimental to the case and would have helped Turtleboy in any way, shape, or form possible. So, yeah. And DC Killing Spree, I touched on this, but I see you said that. Yes, the Brandenburg test is speech can only be restricted if it's directed to inciting or producing imminent lawless action, or likely to incite or produce such action. Yes. Now, there are times where the court can impose certain bail restrictions. Like, that's not an issue here. But this specific problem of, no direct or indirect contact is clearly not direct or indirect contact. And that's the thing here. It's being abused. It's being abused in a significant way. They can say no direct contact. That's fine. They can do that. That's well within their bounds. But it's the state abusing this and causing problems is the ultimate issue here. And I think even under Hess, nothing Turtleboy has said is illegal. Bob saying again, defense diary. So all creators are responsible for the shit our listeners do out in the world. I know that's the thing. There's some people who talk spicy shit out there too. Barb K gifted a super sticker. Thank you, Barb. Turtleboy saying, not a single person could say I've caused them a bruise, broken bones, a cut, just hurt feelings. Yep. Hey, man, those feeler bugs are important, though. People get hurt feeler bugs. It can be dangerous to them. Jefferson Post says, feelings hurt like a heckler's vetoes censoring. Yes. Yep. And that's exactly what we're doing here. It's exactly what we're dealing with here. And Free Karen Reed Buzz says, good thing I didn't do that clip in Massachusetts. Oh, I'm sure. They're like, Your Honor, this fat man's going to get in a helicopter and shoot us with a minigun. I'm sure that's going to be in a filing now. Oh. Is Jen McCabe medicated? No, I don't think so. Yeah, I don't think she is. Let me see here. What are you guys talking about? I'm trying to catch up here. Cal says, I just shot Louis. No, I would never hurt a doggo. I just closed the door. Dylan says, I'm glad you showed up in my algorithm. New subscriber. Well, thank you. Thank you, Diane. I appreciate it. Diane 701. Well, I mean, that means there's 700 other Dianes, but thank you, Diane. I'm glad you're here. Crystal's saying Brennan is such a weasel. Yes, he is. He's a rat. He's a rat. Eric Fulham says you should have hired the DUI guy. From what I understand, Larry was actually involved in the first trial, in like a consulting way. So I think that actually was something that happened there. I've heard that. I'm not 100% sure it's true, but she's got great attorneys. They're doing a great job. Let's see here. These are all thought crimes. Yep, exactly. Yes, there's a puppy. There's a bork. Yes, there are. Let's see here. Let me try to miss anything real quick. Yes, Auntie Bev is the queen of the Commonwealth of Massachusetts. Yes. There's a Republic of Texas. Okay. Yeah. Yes, Commonwealth states mean nothing more, but it's just states feel like it's a thing because they call themselves that. But, for example, like Pennsylvania has been around for over 400 years. So they can kind of do whatever they want. And they keep their names. Let's see here. Vodka Blood for $5 saying, get your wind chimes, get your coffee, tea, and soap. Hit it, like, and subscribe. Eat a sandwich. Yes, thank you. And then Skeeve Man for £5 sterling is saying, I'm looking forward to the coffee, but I forgot just how expensive shipping it internationally is if you're not a Chinese company. Well, even for them, it's going to be tough with the tariff. So there you go. But thank you for supporting T-Man. Vodka Blood gifting 5 subs. Thank you, Vodka Blood. I appreciate that. And appreciate your generosity. Jefferson Post says indirect contact would mean someone is his agent. It depends. I mean, there can be ways you can do indirect contact. Like, let's say, Turtleboy had shown up one night and like stapled shit to every tree in the neighborhood. That could be indirect contact. You could probably say at that point. But merely going on YouTube somewhere else and making a statement, like let's say he drove all the way across town in Boston, like way to the northern suburbs, and gave a speech. Is that indirect contact? No. If he did it like right outside her house, would that be indirect contact? Yes. I think that'd be more fair at that point. So that's where I just think this indirect contact is a bunch of bullshit from the prosecution. But Skeeve Man for £2 sterling is saying in the UK it's a crime not to give passwords. Yes. Do you have a license? Do you have a license to keep that password, mate? It's not a surprise that it's a crime there. Actually, not surprised. How is Tully not embarrassed? Well, when you're a shit-healing cur of a human being like Tully is, you don't have shame. So when you don't have shame, you can't really be embarrassed. When you're a cuck of a man, it's hard to be embarrassed as well. So that's really the answer there. Leaving a voicemail. Well, yeah, that all happened at the beginning, though. Crystal saying, when are you going live at the casino again? We love it when you hang out with the boys on Keno Casino. I don't know. They've been busy. They've been kicking ass. I just have to reach out to them when they're ready. When they got something they need me on for, we'll talk. But Worski and PPP are taking care of business. Reformed Convict says, Virginia is the first ever. Suck it. We are the Commonwealth. All others are cheap reproductions. Well, I guess. I'm happy to be, Ohio. The one cool thing about Virginia is their flag has boobs on it. So they got that going for them. Yes, California still calls itself a republic, and it's more like a third world hellhole. Well, yeah. Yes. Kentucky, the Commonwealth of Kentucky rebelled by not calling itself a state. Yeah, but I remember Kentucky, like right after Ohio, it was one of the, I think it was like Ohio, then Kentucky got admitted to the Union. So the Union. So, it's right there at the edge of the the beginning of the 19th century. I could see it. Yes, Larry, the DUI guy, is representing the vlogger guy, Bao, that got arrested. Yes, which is bullshit. Let's see here. Are the McAlberts now an accessory to murder? I mean, well, they probably are ultimately, but not for now. So Randy says, how long do you expect the Karen retrial to last? Well, the first time through the Karen retrial, I went 30 days with 30 actual 30 actual days of court, like 30 business days. I bet it goes at least that long, probably closer to 40, if not longer. I mean, I think there's going to be a lot here, chat. There's going to be a lot here. So I bet it goes at least 30. Again, it's going to be a marathon. It's going to be a slog. It's going to be a slog. It's going to be a grind, guys. But that's how these are. That's how these are. I threaten you guys all the time as Greys. Well, yes, but it's because you guys are godless people, the Greys. Oh, you called her Dylan. I know. I was trying to read and move around in 1 second because there's a bunch of people. If you guys are over on Twitter, but please feel free to throw a comment up. I will see it if you put it there. And I don't know why. I'll just pop my Twitter feed out just to make sure I can see as well. Let me see. Hold on here, chat. There we go. Just making sure that's out there. Oh, there we go. All right, I'm keeping that off to the side. What else we got here? Yes, I'm sorry, Diane. I didn't mean to call you Dylan. Yes, Jen's testimony is very coach, so she is in a lot of trouble there. So we'll see. I'm starting to look like Saruman from the Two Towers. Well, thank you. Is Higgins going to break down? Ron says, will you see it? Yes, Ron, I see it. Ultimately, is Brian Higgins going to break down? I don't know. I don't know what's going to happen, chat. We're barely into this. We're barely into this. And I said it before. You can't ask somebody and be sincere. Hey, the first inning's over. Who's going to win the baseball game? There's a lot of baseball left to play. And do I think they're going to make Brian Higgins look like an idiot? Yes. But you have to remember, guys, all these people, all these scumbags, who prepared? Yeah, Karen Reed and Ellen Jackson and Yannetti, they put in that work. They got Alessi on the team. They've been working hard. They've been putting in that time. They've been honing their skills. They're just like in Kill Bill. They're sitting there practicing with their swords. Guess what? Jen McCabe was practicing on her own, too. Brian Higgins is going to have practiced on his own, too. They're going to be ready. They're going to be ready to fight. And you saw Jen McCabe. She was ready to fight. She knew it was going to be a gunfight the moment she walked in there. Carrie Roberts wasn't ready because the first time through, nobody went after her. But now the second time through, she was not ready and she got fucking trounced. But no, like all these witnesses, they've been, going over it inadvertently in their head for months and months and months on end. So I don't think he's going to break down, but he's a cop. So he has enough training to hold his own and he can lie reflexively as a police officer. So, he's a Fed, but still. He's going to get, but all that information that kind of got elicited out of him by busting the phones and throwing them away, doing all that, knowing the orders are coming in. Yeah, he's going to have a lot of problems. Demon's Rat says testing the mods are queers without exception. Fuck those queers with a howitzer. Well, yes, that's true. They're Jannies. So I still don't know. I still don't know what's going to happen. I'd like to see Karen Reed get acquitted, but who knows what's going to happen? We don't know yet. So I can't give you an answer there. I can't give you an answer. Idiot Wind is a new member. Thank you for your support. I appreciate it. Doing your part to help make this chat green again. It's gonna look like a golf course, just green everywhere you go. Yes, another gray bites the dust. J Rock's all upset. Well, you're a Janny, man. That's how it works in this world. You accepted this badge. When you don that badge, you knew what you're getting into. Let's see if you guys have any other questions here. Mavka says the massholes are retarded. They will probably convict of only count 3. I think it would, like I said, Chet, I thought it would be absolutely hilarious if for some reason they were able just to convict her of OVI. Not even OVI where there's leaving the scene where a death occurred. Just regular, just operating a vehicle under the influence. Just an OVI DUI situation. Just a regular DUI. That would make my day if that happened, because that would be hilarious. It'd just be like the ultimate. Because that would be even more embarrassing that not only did you not prove all this, we just only thought she was drinking and driving. That would be hilarioso. Beautiful Waterfalls is what I missed. Did someone get banned from chat? Nope. James Reed says, if this gets hung again, do you think they will try it again? I could see it. What do I think? Do I think it'll happen? I don't know. Would they let this go? As of right now, they haven't let it go. They've doubled down. I could see a third trial. Now, like I said, I hope Karen Reed gets acquitted. Knock on wood. But no, a third trial. Oh God, that would be insane. I don't know how you. At some point, like you've done everything you can. So I would argue if they don't get it, I would hope Judge Bev has the stones to just toss it after this point. So let's actually hope there's a verdict, and let's hope it's a not guilty. I don't think we don't need to shoot for a thing. They will not go after themselves. Yeah. Where Tiger Ray is saying, won't most judges shut down a third trial? No. Just because third trial alone won't actually mean anything. If you guys read, there are people every once in a while get tried 4th, 5th, 6th time. It's not uncommon. Not uncommon. A cool channel name. They're saying the more I learn about people in the Reed case, the rest I want to know. Yeah, that's the other thing too. You learn about all these people, and you learn, wow, a lot of them are fucking assholes. Like, you don't really want to know about them, but you have to. I really want to see Jen McCabe on the stand a third time. Oof. How much more facial work she can have done in the next trial? Half these women are going to have so much Botox that their faces are going to be like, they're going to look like they have broken jaws. Yeah, I we went out there and we saw John in the snow and we walked up to him. John. Like Jen McCabe's going like a fucking ventriloquist dummy at that point. A tanned up ventriloquist dummy. Yes, the state did want to retry George Kelly. Guys, if you don't know George Kelly, he was a he was a rancher down in Arizona. He is accused of murdering a guy who had been crossing the border illegally, and they claimed he was just some guy going back and forth, and he was innocent and didn't do anything wrong. And it turns out he actually may have been part of, like, human trafficking, and some, cartel members and other gang members with guns assaulted the homeowner, and he returned fire and hit this guy. So yeah, they were looking to retry him, but the court, took care of that issue, and the lawyers took care of it too. So you'll trust her be acquitted this time, provided her attorneys do a good job making the corruption obvious. See, I don't think that's the route they need to go. I think the better option they can do is just focusing on the corruption as like a secondary issue. Because if they, like the first time the case started, at first, that first opening, Karen Reed was framed. I thought it was very powerful. So you get through the case, you're like, but she wasn't really, like, we know she's framed, but the evidence didn't show it the way they promised it. Instead, just say, look, John O'Keefe's dead. Nobody can prove it. Walk this home. And oh, by the way, every witness you've heard from, you can't trust. And here's why you can't trust all these witnesses. And then here's why you can't trust the police. That would be the way to do it. That would be the way to do it, I think. Do I think all of her attorneys would stay on for a third trial? I think they kind of have to. Well, God, that would look really bad if they bailed on her. But, money becomes an issue. How could she afford another trial? I don't know. I mean, that's part of the issue. She's been getting a lot of support from the community and her family and other things, but eventually, yeah, the money runs out. The money runs out. I think Morrissey's committed to putting her in prison. Yeah, but at some point, you got to take your L's. Blaine is saying, did I miss the Turtleboy stuff? Yes, you did. And Turtleboy, if you're out there, have a good night, man. So, yeah, I would focus on the reasonable doubt here. Get the win, and then really just hammer all that other stuff. Because you're not going to exonerate her in this trial, because nobody's going to admit to it, doing everything. They've established the corruption. I mean, yeah, they have a little bit, but as long as they just point it out. Okay. Crystal saying, what if John just fell? I mean, that's a possible answer. John's in the house and he falls and cracks his head. I mean, it doesn't explain the dog marks on his arms, but the idea that somebody fell, cracked their head, and was like dying, and everybody inside the house threw him outside, that happens in colleges across America. If everybody's drinking and everybody panics. I mean, do I think a lot more happened there? Sure. Could I see the dog attacking him and then, like, stuff going on? Yeah. But is there enough to prove it? No. James Reed said, I saw this has already cost Karen $5 million. Oh, I don't doubt that for 1 second. Like George Zimmerman's case back in 2012 was millions of dollars. Doing the second time through, yeah, it's going to be millions of dollars. So Bev won't let them return for part 3 due to misconduct. She wouldn't be able to fuck around with it like that. So no. Ray is saying no justice for John O'Keefe. I mean, the justice is the real killers going away. If somebody killed him, them being there, Karen's not the killer. So yeah, John's not getting justice. But that's the police's fault. That's the police's fault. Yes, the state relies on you running out of money. You guys say she can go on OnlyFans. Jeez. Turtleboy's going live. Cool. I might send you guys over there. Chugi Show saying, read us the email you're sending about super tips. I don't talk about those things out in public. Sorry, guys. Distant says, how does Karen Reed have $5 million? Well, she was very well off on her own. She worked in the financial sector. I mean, Karen Reed was doing pretty good for herself. Her family has some money. I'm sure they've cashed out and leveraged a lot of things. But Karen Reed has received a lot of donations and support from the community, primarily because of people like Turtleboy. They did a great job doing that. So she's had a lot of support. A lot of support. Beautiful Waterfall says the crash daddy testifying O'Keefe was not hit by a car. Remember, they didn't care. That was not something they focused on. The first jury was like, that didn't matter. So you'd like to think so, but remember, jurors are weird. Jurors are weird, man. Heard Alessi's $1,800 an hour. I could see it, man. Alessi's an appellate attorney with an appellate specialization. And appellate attorneys, man, the cost goes up when you do that. So yeah, I could see that easily. Yeah, she sold her house. Yeah. So I mean, if that's a thing, she'll end this and she'll have no money. That's the thing. I mean, but like, 'cause at the end of the day, Karen's going to be a woman who's almost 50 and broke as shit. You're probably not going to be able to get a job, like a good job again. So the process will be the punishment for her, sadly. Sweet Tooth saying a model stream. Yeah, we're going to do a model stream probably about 10 o'clock. We're going to finish up here, though. Yes. Promote the locals. Got F1 tomorrow. And also a gym stream or two for yes. Yes, guys, if you guys want to join us, if you guys like me and you have fun over here, you can, guys, join me over at potentiallycriminal.locals.com. We are hanging out tomorrow. We got the Formula One race. We got Mr. Medicare going live, all that. But we will do that over there. So I hope to see you guys over there tomorrow. It should be a fun day. Use the promo code WHIPIT, and you get 1 month free access. The main reason the Alberts hate her is because of her success, probably. Yeah, the first jury disregarded ARC as a distraction. Well, part of the issue was, they acted like they just came out of nowhere in the case, which they did. So the jurors kind of disregarded it. So yeah, that's a problem. That's a problem. Bella's saying John used her as a babysitter in a checkbook. I could see that too. Yeah. She could make more money. Yeah. But I'm just saying, like, it sucks. It sucks when you're there. It sucks when you got nothing, but at least you're not in jail. Dirty Hanky saying Alessi is pro bono. Well, that's awesome on him, dude. Being able to devote this much time pro bono. It's one thing, like, I've done pro bono stuff before, and you do case to help people out here, there, like, whatever. But it's like doing all this shit pro bono. Who, buddy, man? He must be like, that's nice when you're doing things well off like that. Yeah, Karen's $5 million in debt. Like I said, that makes total sense. Easily. Aaron Hex, it's like the Matthew Moore case. He could afford Diane Menashe, but now he has nothing. Yeah, but you know what? Still better than being in prison. So let's see here. The first jury also saw no problem with Jen McCabe. Yep, that's always a problem. You just don't know what they're going to do. You don't know what they're going to do. So with that said, we are all caught up tonight, chat. Thank you for everybody here on YouTube watching. Apparently there's like 5,000 ghosts watching over on Twitter. Thank you all for being here. But with that said, guys, we are going to end here. We are going to go over to paint. We got some, guys, if you guys, I paint models. It's a fun thing to do. It's my hobby. So we got some stuff to paint and work on. Some little miniatures. And we'll be doing that probably in about a half hour. So I got to set that up. So in the meantime, chat, I'm going to send you guys over to Turtleboy for a minute. And just remember until next time, chat, just because you did it does not mean you're guilty. And Turtleboy is definitely not fucking guilty. And Karen Reed is not guilty as well. I mean, both of them, they truly are not guilty. Like I said, this has been a disgusting thing that's happened to these guys. And sadly, them winning is probably all they get out of it, is just being able to, just freaking flex on the state and go like this the whole time. Like, that's all they're going to get out of it. Like, that's all you're going to get. But you know what? Sometimes that's all you can get. So, like I said, I wish they could get more, but yeah, I don't think they will. So, let me see here. Yep, he's on. All right, there we go. So, with that said, chat, I will see you guys in a little while. Take care, everybody, and have a nice day. Once again, these guys will be righteous. It's just going to take a little while. Weapons, blacksmithing, and models of planes.
esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fact